Welcome to a special edition of Eye on Bankruptcy, coming to you from the annual spring meeting of the American Bankruptcy Institute. Our guest is Chief Judge Barbara Hauser from Dallas, which is the northern district of Texas. Judge Hauser has been on the bench since 2000, so that's
right. 17
almost
years.
18 years, going on 18.
Going on 18.
Exactly. And before being on the bench, she was with two of the finest bankruptcy firms in the Southwest, namely Locke Purnell and Scheinfeld, Bailey and Kay. And I must say, I have very fond memories of Mickey Scheinfeld and his Coke bottle glasses. A wonderful man, that's all you can say.
Yeah, that is all you can say, Bill. He is a wonderful man.
That's right.
And still chugging along.
So I hear. God bless him.
God bless.
The longer the better. Well, Judge Hauser, I want to talk with you about a couple of topics today.
All right.
Intellectual property, which was the subject of, or valuation, I should say, the subject of your panel. Also, got to talk to you about oil and gas because, Lord of mercy.
Because I'm a Texas bankruptcy judge, right? So you got to talk to me about oil and gas.
Precisely. And if it weren't oil and gas, there wouldn't be much work these days for bankruptcy folks. But let's talk about valuation first. I looked in on your panel a little bit, and one of the topics that you talked about was intellectual property. Typically, that has not been a big topic in valuation, but why is it now?
I think, frankly, Bill, because the lawyers and the parties have become more sophisticated, and you probably have more high-tech kind of companies that are filing for bankruptcy protection. So you've got more intellectual property assets, some of which may be captured in the context of evaluation in a discounted cash flow analysis. But if the assets aren't actually generating cash flow, then they may not. And I think lawyers have gotten more sophisticated about, and creditors, looking for value. And intellectual property can provide a lot of additional value that people, I think, traditionally didn't stop and think about.
Well, that's interesting. Now, are you talking about trademark and copyright, or software, or other kinds of...
The whole panoply: copyright, trademark, software, patents, anything that gives rights to the debtor that then can be hopefully liquidated in some fashion or reduced to cash, monetized, and then those cash values can be distributed to creditors.
I understand that one of your panelists was involved with the estate of Michael Jackson. What was that all about?
Well, he was, and the dispute, and I'll be cautious because he required being cautious during the course of the panel discussion, but the estate of Michael Jackson apparently filed a estate tax return suggesting that all of Michael Jackson's intellectual property had a value of, I may get the number slightly wrong, but very low, $2,500. And the intellectual property that Michael Jackson had an interest in was vast. And so the Internal Revenue Service, who disagreed with that valuation, hired one of the firms that were speaking on the panel yesterday with me, and they did a complete valuation of that intellectual property. And to say that they disagreed with the estate's view of value is a modest understatement. I think the swing is 9 figures or more.
Oh, wow. Wow. Woo. Well, I tell you, listen, let me ask you, Judge Hauser, about intellectual property valuation issues from your side of the bench.
All right.
You being the judge who's going to have to understand the evidence and the testimony and make some decisions. What is it that makes for a good expert witness?
Well, what I like to look for is first someone who's well credentialed, obviously, but that's generally not an issue, particularly in a larger case where you've got sophisticated valuation disputes going on. So if you've got 2 well-qualified experts on paper, then the issue to me is the explanation of their valuation and their approach, and making it understandable to someone who's not necessarily an expert in valuation, although someone who deals with those issues more often than perhaps he or she would like to. But what I look for is someone who can take both valuations, if you have two competing values, and distill the differences in those approaches so that someone who is not necessarily an expert can really understand what's driving the difference in those views. So if there may be four factors, hypothetically, that form the basis of the valuation, and the parties aren't really in disagreement on two of them, isolate that for the court so that I know I can put those two factors aside. I don't have to worry my pretty little head about those two factors anymore. I can focus on what the heart of the dispute is. And it's important not only while I'm there hearing the testimony, but it's almost more important that that isolation be provided to me so that when I go back to chambers and I make my decision as to who I think was more credible or what I think the correct valuation answer is, I know what's not important because the parties basically agree on it, and then I can focus my analysis on the issues that are really in dispute.
Well, what about visual aids? Have you found in connection with expert witnesses that using visual aids is helpful from your side of the bench?
It can be very helpful. Let me give you an example where I found visual aids to be almost imperative. In my Wiley trial, and I'll be careful here because the issues are on direct appeal to the Fifth Circuit, the issues in dispute between, in that case, the debtor and the Internal Revenue Service related to some very complicated offshore trust transactions that occurred. And the transactions were extremely complicated. We had domestic entities, foreign entities with similar names, and very complicated transactions that were occurring both onshore and offshore. And one of the experts had prepared a report that included some visual aids, some just graphics that would show me how the transfers occurred, just mechanically how money moved from entity to entity. I found those so helpful, but I wanted to be sure that both sides, if possible, agreed to what the graphics were, that I actually asked the parties if it was possible for representatives from each side, the Internal Revenue Service on the one hand and the debtors on the other, to prepare agreed graphics, if possible, that I could rely upon. They were largely able to do that, and I believe we admitted those into evidence. And I can't tell you, Bill, how many times after a almost month-long trial, when I was evaluating the voluminous record that was created during trial, how many times I returned to those graphics to just make sure I understood the transactions before I tried to analyze them legally. So it can be extraordinarily helpful depending upon the case.
Well, that's an interesting point. It really goes to the issue that documentary, well, that's not really, well, I guess it's documentary evidence in some ways, but visual aids, charts, graphs are really useful to a judge when she's sitting down trying to parse out the findings of fact that she's going to make.
Absolutely critical in that case. Again, I can't tell you how many times as I was thinking about something or I was reviewing someone's testimony, because we had daily transcripts, and so I might go home at night taking a transcript from the prior day and make sure that I understood the witness's testimony, because as you can imagine, in a month-long trial, the testimonies building upon each other. And so it was pretty important to understand the prior day's testimony before you heard the continuing testimony. And those charts proved to be just absolutely invaluable.
Well, this, by the way, is also an interesting point that we on the other side of the bench don't know, and that is a diligent lawyer like you is studying this stuff in mid-trial.
Oh.
Which I guess is not surprising, because as I recall, your opinion came down pretty quick after the trial was over.
It did, but but you have to. I mean, if you're, again, we knew it was going to be a lengthy trial, and we knew the evidence was going to be conflicting and complicated. So it was important to me to be sure that I understood the testimony as we were progressing in the trial. And frankly, if I had questions about a prior day's testimony, I might ask for a clarification from the lawyers about something that wasn't crystal clear to me.
Yeah.
I didn't want to enhance the record, but if there was something that I thought was important that I just wasn't 100% sure of, I might ask them to clarify at the outset of the next day's trial.
Yeah. Well, listen, tell you what, let's talk about oil and gas for a minute. This morning, as I was doing research for my column, I came across a brand new report and recommendation that you made in the helicopter case. So I'm guessing that that's part of the oil and gas fall-off that has bounced into your court. Is that right?
It is. The case was really quite interesting. That report and recommendation, sometimes, Bill, as a bankruptcy judge or as a bankruptcy lawyer, you think, how does this come before me? Like, $1 billion plus tax fraud suit in the Wiley case. But in the issue in that report and recommendation is sort of fascinating. It's between two non-debtor parties, and it is a equipment lessor to the debtor whose lease was rejected, who has potential products liability claims against the helicopter manufacturer.
Oh, wow.
Both of whom asserted claims against the debtors in my case, and it is on that basis that there is an argument that I have related to jurisdiction over products liability, a very complicated products liability lawsuit between two non-debtor parties, an owner of a helicopter that crashed off Norway, and the manufacturer of that helicopter that's based in France.
Oh, wow. No wonder bankruptcy judges are generalists. So how has that case been handled in your court? Because it's a biggie.
It was a big case, and it was handled, I must say, by all the lawyers involved beautifully.
Was there a lot of blood and guts litigation, or how did it work out?
It worked out. We had 3 contested hearings, really, in the case. We had some contest on first days. It was a general contest, and it was mostly because of the speed with which things were progressing in the case. And then we had contested hearings on a plan support agreement, and then a modestly contested confirmation hearing. And otherwise, every other issue was settled, or if there was potentially going to be an issue, it might get continued so the parties could continue a dialogue. So the parties moved quickly because the debtor had serious liquidity problems when it filed, and people were focused on a speedy emergence.
Mm-hmm. Well, oil and gas has always struck me as a bizarre area of the law. I mean, I always practiced law in the Northeast, so we ain't hardly got no oil up there. So.
Yeah, but you grew up in Texas, buddy.
Well, but I learned that knowledge of oil and gas law is not genetic. It's a learned talent.
A reference, of course, to your esteemed father.
Well, and I frankly remember when I was a kid how he brought home an oil and gas textbook. First time he had a decent oil and gas case, he had to learn oil and gas law. And that's what I want to ask you about. Is oil and gas law as complex and as difficult as I think it is?
I find it to be very complex, yes.
Well, you've been dealing with oil and gas law ever since you've been a lawyer, I guess. But you still find it difficult?
Some 39 years, yes. I mean, I think oil and gas is a very difficult area of the law. And you're right, I've dealt with it off and on over my years as both a lawyer and now as a judge. And it remains an area of the law that always requires careful thought and analysis, and frequently the analysis of many other state laws.
Oh, really?
Where the company may have oil and gas properties or wells, and there may be lien perfection issues that come up.
You mean the law is not roughly equivalent among the states?
Not even close.
Really?
Correct.
Oh dear.
Some states, it can be considered personal property. Other states, it's considered realty. Perfection issues are different depending upon the states. Recording statutes are different. What you have to do to perfect M&M liens, if you have someone who's been working on the well and didn't get paid, can differ. So there are frequently, very, very complicated issues that turn on the law of the state where the well is located. And frankly, if there are perfection issues in a case, it's often because the lender, the overwhelming majority of the collateral is in, pick a state, Texas. So the lender's lawyers are sure that they've perfected properly in Texas, but there may be a smattering of other properties in Oklahoma, Louisiana, New Mexico, or other surrounding states, and they may attempt to perfect as it relates to those assets, but because there may not be that significant a value there, they don't spend the time or money to ensure that they've perfected properly, hoping that it must be similar to Texas. And later they may find that that hope was misplaced.
Oh my goodness. Oh my goodness. Oh. So it sounds like oil and gas law is at least as difficult as bankruptcy law.
I think at least. And then when you have a combination of the two, think what fun that is.
Oh, Lord of mercy. Oh, good grief. I'm glad you have to combine those and not I. Judge Hauser, I thank you very much for your time. Be well and keep cranking out those interesting opinions.
Will do. Thank you, Bill.